So I could say. Great.
Well, no, you think this. Ture code. So welcome everyone to today's Bioethics seminar. It's my great pleasure to introduce Alison, who is friend of the centre and a colleague. And I was thinking about it actually in terms of you've had a very long association with the Bioethics Centre, and it even predates Neil and Josie doing any bit of gel here. So Lindy and I is going to time as the centre. Maybe Jing Bao, you might have been here. So Alison has been doing some great work on capacity. We did a book together. It's been a long to show anybody. And this Law Commission report, New Zealand Law Foundation report that she might talk about too. So some interesting things happening in this space. I'm really looking forward to hearing what you've planned.
So I'll position myself here, right?
Yep.
Okay. Rau rangatira mā, me mihi ki te hau kāinga, tēnā koutou. Ka nui te mihi ki te whānau, pokapū, matatika, koe ora, the Bioethics Centre, who I regard as my sort of collegial whānau, and also to the people that are beaming in. Thank you. I'm sure there's some friends and colleagues among you. I don't know who you all are, but thank you. I'd actually like to begin by, first of all, taking this opportunity to actually thank you and acknowledge you all on behalf of myself and my husband Peter regarding the loss of our daughter last year. I just wanted to say that, so thank you very much for the support. I'm back on track, and in fact I've actually been very busy in this space, so that's essentially what this talk is about today. Which is on capacity and supported decision making, and to update you all on the law reform. The Law Commission, of course, is well underway with a review of adult decision making capacity, and that's why things are really on the go at the moment. So what I want to talk to you about is, first of all, place this all in context in terms of a timeline of the disability legislation that we have in New Zealand, to put in some things that are around human rights and the Triple PR Act. Of course, that refers to our adult guardianship law, the Protection of Personal Property Rights Act, some common law developments, some of which I've been involved in, and then Te Ture Matua or Te Ture, the New Zealand Law Commission has picked up a review of this area of the law, and I want to focus just a little bit on ethics and tikanga, working in partnership in this law, and look briefly at models of supported decision making. And then finally, tirahira ki te tahutu o te rangi, looking into the horizon. So I will give time for questions. So what would be a good time to stop, John? I
think so 22 would give a good sort of 10 minutes.
Okay, so someone could wave at me, and actually I'm happy to have the odd interruption. So, so I thought you might find this slide interesting, because like the sort of our Commonwealth laws, and in particular in the United Kingdom, the areas around capacity and decision making really go back to the lunatic laws, starting there in 1868. I mean, I can actually in legal history take you back to the Magna Carta, and indeed the establishment of the parens patriae jurisdiction, the inherent jurisdiction that the court has. But, you know, rolling the clock forward, it's, you know, over the last 150 years, on the left are the sort of what we might call the compulsory treatment laws, where we have the society has held people for the purposes of their mental health treatment, if we can call it that. And most recently, there is a sort of what I call the trio of compulsory treatment laws. There's the Mental Health Act, 1992, the Intellectual Disability Compulsory Care and Rehabilitation Act, the IDCCR Act. That is a law where people with intellectual disability who commit criminal offences come under the health system. And I myself have been involved with representing people in the appeal courts around the human rights around that particular law. It's unique to New Zealand, but it sits there in that trio. And the most recent one, of course, is the sometimes known as the SACCAT, for those in the know, the Substance Addiction Assessment and Treatment Act 2017. That's a law that's come into place and may well be a kind of model as to how the new Mental Health Act might come into place. We'll come back to that. But on the right, you'll see that in 1988, the Triple PR Act came into place. It was seen as a modern law, a human rights-based law, and it is. It's got a lot of good bones to it, good principles about the right to the least restrictive intervention, and also recognising people, maximising people's participation in decisions that affect them. It does have some limitations, and procedurally is way overly complex, and it's out of date, it's not fit for purpose, but it does have some good principles that support it. So we shouldn't sort of lose sight of that. And then there, of course, there's, around that time in the early 1990s, we were getting the Human Rights Act, New Zealand Bill of Rights Act, the new Code of Health and Disability Consumers' Rights. And then rolling the clock forward is the Convention on the Rights of Persons with Disabilities. And that was in 2008 that New Zealand ratified that convention. And essentially the law reform that's being driven at the moment is around how we can implement that Human Rights Convention into our domestic laws. So the Triple PR Act, it is an adult guardianship law. It is for adults 18 years and over. And there's kind of two parts to it. If you think of it, it has for court orders where we decide someone lacks capacity for decision making, then the court may intervene by appointing a welfare guardian, property managers, that sort of thing. Where a person has capacity, then they can make enduring powers of attorney, EPOAs, and they also can be in property, personal care and welfare. The CRPD, that's what I refer to it as, or the convention, really supports the idea of enduring powers of attorney, because it's saying to people, when you have capacity, instruct someone else to be the person to be your decision maker at some time in the future when you lack capacity. And that's a similar idea to advanced directives. So there is the automatic appointment, of a lawyer for the so-called subject person. And one of the things around law reform is what sort of new terms and names are we going to use? I've been a Triple PR Act lawyer for the subject person for, I suppose, about 30 years now. Then I do a lot of work in this space. The Law Commission is actually suggesting a term like affected person. I don't quite like that. Other legislation overseas, I know it talks about a relevant person. And of course, in the mental health space, there's the frequent use of the term tangata whai kaha, a person that possesses strength. So anyway, that's one of the details of words. But the automatic appointment of a lawyer is significant, and sort of without dropping names, when I did go and interview Lady Hale in the Supreme Court in England, and she said to me, "Oh, but Alison, you under your law, you have this automatic appointment of court-appointed lawyer. They don't actually have that in England, for example. The official solicitor doesn't always step in. And it is actually a really important part, actually, of supported decision-making processes. If it gets to the point of going to court, that they have representation. So this is the convention, and I'm assuming that some or all of you have some knowledge of it. what the focus is here is around Article 12.3, which I put there as supported decision making. And that requires state parties to put in support measures for people to enable them to make their own decisions whenever possible. And that's really what's driving the law reform. So that's Article 12.3. And then against that is the requirement under Article 12.4 that there must be safeguards against abuse that reflect the rights, will and preferences of people concerned and are free from conflict of interest and undue influence. So you'll be aware that the UN Committee comment in 2014 was highly critical of the way New Zealand's laws, as with other Commonwealth laws, in terms of not being compliant with the CRPD. They recommended abolishing the Mental Health Act, essentially the compulsory treatment laws, and indeed adult guardianship laws, because the argument is that there really should be support of everyone. Everyone should be equal before the law and should have the opportunity to support their exercise of their legal capacity. I think, you know, in the so there's been a lot of international chat, a lot of articles out there around, and law reform reports from other countries. I think probably where it's heading is that there is likely to be some retention of, and I'm speaking now of the PPPR Act or some equivalent to adult guardianship laws. I think there's a recognition that there is a need in some circumstances to have other people make decisions. You know, some of the very obvious things, if you're sitting in a coma and there's no one there to make a decision for you or represent your interests, then, you know, but we can talk a lot about that, but we think of it as a continuum. So this is the Article 12.4, which set out in full. So, and also that these are sort of finding solutions that are proportional and tailored to the person's circumstances. The CRPD is not creating new rights, it's really collecting existing rights. It's a shift from the medical model of decision-making to a social model, asking the question, what are the social barriers for the exercise of this person's ability to make decisions? So I did do a law reform report, and I've you know, presented on that a few years, it is a few years back now, I might add, it's 2016, and slowly but surely my recommendations did find their way to the Law Commission, and I'm sure there was, this whole area was brewing for the need for law reform. So I'm very pleased to say that the Law Commission is moving forward with this area of law. I did highlight in that report the need for a code of practice, and I see that as a real strength of other countries' laws in this area. And also, having worked in law and policy in the health space over many years, I see that New Zealand has a real almost tradition of working from the ground up, and that if you can get embedded in practice, processes and practices, then the law will follow. And we've got lots of examples of that. And I've been involved in the ART space, as have many of you, on assisted reproductive technology. You know, I mean, fertility clinics didn't allow donors unless they were prepared to be known and identified at some stage. And that came from way back in the 1980s, 1990s. That was a practice well before the law. And, you know, we then created the Heart Act, and there was the right to know your genetic origins. So what I'm saying is, I think it's really important that the more we have embedded in practice and the principles that we follow, that these can then become part of the law. I was concerned about the gaps in the law around liberty safeguards. So that is something that's also on the Law Commission's agenda. And there is the issue of research on people with impaired capacity, that is, people unable to consent. And that's another whole topic. I'm not really up to date with where that is up to with the new health commissioner. But I would argue actually that the revision of this law, this adult guardianship law, whatever form it takes, there would be a place for including basically what we're looking for is law, and it has to be law. It can't be an amendment to Right 7.4 of the Health and Disability Code, which would say we're not talking about the best interests of a person here. What we're saying is that if an ethics committee is satisfied that there is minimal harm and there can be benefit from this research, not necessarily to the individual, but to society, then that should be a safeguard and allow for research in that space. And we're starting to look silly internationally. I actually think this is a really urgent issue. We all know we've been through a very lengthy process with the former Health and Disability Commissioner, but also to allow, research on people with disabilities. They can't consent. People with dementia. I mean, so many areas. And people stuck in ICUs, really, really important research. So, and in my research in England, I actually interviewed a number of the players there, and basically the English law, the Mental Capacity Act, and the Scottish law, Adults with Incapacity Act, their parliament quickly moved to put in laws around this area over 20 years ago, and they didn't really have any difficulty in doing that. So as part of the code of practice, as you know, with John and our colleague psychiatrist Greg Young, we wrote the toolkit, and that's freely available on my website. And we saw that as a really good way of embedding and putting clarity and transparency into how do we decide whether someone lacks capacity. And I'm now quite involved with training lawyers as well. So I've moved on from doctors and others, but it's a very active space at this moment. And of course we wrote our book, and a number of you have contributed to that book with sort of case studies, the whole breadth of how capacity affects areas of the law. So just a couple of examples where the toolkit's actually been applied. One is we've talked about in our book about a case in the family court about whether a young woman with disabilities had capacity to consent to marry. And that law actually sits in the Family Proceedings Act, and whether the person has absence of consent. And Judge Coyle in the family court went through the toolkit, which was talking about the functional test of capacity, and worked out that this young woman wasn't able to understand the nature of the marriage contract she had entered into, and actually did discuss the convention in terms of supporting her in how at a future date she may well be in a position to have capacity to consent to marry. And just a note there's been a few HTC complaints, and one is that Dr. C case where the expert advisor, it was regarding a GP, and we don't need to go into the details of it, just to note that the expert advisor regarded the toolkit as the standard for capacity assessment. But if you come up with an alternative, that's fine. But it's good to see that we're actually making an impact. And then across, in terms of common law developments in New Zealand, I was involved in this case in the Supreme Court, which the decision came out last year. It was a bit of a journey, but essentially it was an appeal from the employment court where my client had a breakdown from her employment situation through bullying and harassment and was on sick leave, and essentially she signed a settlement agreement, and these are very, very common in employment law, and most personal grievances in New Zealand, or personal grievance disputes, are resolved through either a mediation and or a settlement agreement of this kind. So it has a huge impact. But the employment court judge said, well, actually, while I find, and then we had a psychiatrist give evidence, that TUV lacked capacity at the time to sign that settlement agreement. The contract law says to set aside that agreement, you need to not only lack capacity, but the other party has knowledge or ought to know or have And in that case, the employer didn't know, and the judge found that to be so. So she said, I'm constrained, you know, we've got a 2-limb test. And so even though I acknowledged that she lacked capacity at the time. So off we went to the Court of Appeal and then to the Supreme Court. And we had, it took its own journey, but what we discovered along the way, and this was interesting for me as a Triple PR Act lawyer, that there is a quaint old provision under Part 9A of the Triple PR Act, which allows court-approved settlement agreements where a person is unable to manage their affairs. So then the debate became in the Supreme Court, should this apply? Should you be allowed to retrospectively go and get your agreement approved just to be sure that the person, you know, is making a valid agreement? And the majority held that it didn't apply. So we lost in the Supreme Court. But we had a great old discussion about the convention. We had an intervention by the Human Rights Commission. I'm very grateful to them. They put on a sterling argument, and we had the Chief Justice come out in the minority decision, swinging, politely, I'd like to say, disagreeing with the majority, saying that even when the incapacity was not known at the time of settlement, it is consistent with Article 12 of the Convention to have these safeguards, like getting court approval of agreements. Because clearly in the employment jurisdiction, the fact that the employer didn't know, oh, by the way, she had a lawyer, they didn't know either. And so was representing her client in that context. And then finally, the mediator, who they approved these agreements by telephone. So all of those people, you know, let my client down. And I say that there shouldn't be a 2-limb test. There remains a 2-limb test. But what we can say is that there is a recognition by the Supreme Court that it is important to look for and use the safeguards that we have available to us. So this is a bit of a long quote, but in the middle there it says, it is consistent with respect to the inherent dignity of the person subject to disability to hold them to contracts they entered into without capacity and the outside protective mechanism the law provides. We accept the Human Rights Commission's submission, and it allows respective approval of settlements is the reading and most consistent with New Zealand's obligation under Article 12 of the Convention, as it enables the court to decide whether measures taken relating to the exercise of legal capacity were proportional and tailored to that person's circumstances as required. So, yeah, so that's interesting. And so I have managed to split the Supreme Court as to how the law ought to provide, but it's good to see that, you know, we are trying to drill down and get the convention, you know, what does it mean to us in law, you know, and how does it affect people's lives and how can it be used? So there's also recent legislation. So this is the functional test that we used from the Mental Capacity Act. It's equivalent to the various tests in the Triple PR Act. We saw it as a simple retain, understand, retain, use away, communicate functional test about a person's abilities. There is a presumption of capacity, but if a person is unable to understand or any of those 4 abilities, then we can decide that the person lacks capacity for that decision. So that's the functional test. And that's now popped up in this substance addiction legislation, which is a bit like the Mental Health Act at the moment, but it's got this other layer of consent or inability to consent, in that case to your severe substance addiction. That law has very limited ability to get people essentially under a compulsory treatment regime. There's only one facility in Christchurch with 7 bed placements. So it's kind of, but what it does do, it kind of mirrors sort of a modern mental health legislation in that it builds in capacity or the issue of a person's inability to consent into the criterion to bring the person under the compulsory treatment law. And of course, the other law is the End of Life Choice Act, where the meaning of competent to make an informed decision about assisted dying essentially has a similar sort of functional test. So the other developments in the common law, or the case law in New Zealand, is around tikanga. And of course, you all know about the Alice case, which was the Christchurch creche case. And essentially, after Peter Alice died, the Supreme Court allowed his appeal to be heard. And his convictions were quashed. So the court sort of moved on to a second aspect of this, which was, where it took the opportunity, if you could, I would explain it that way, to talk about tikanga, and the Supreme Court confirmed the broad application of tikanga as the first law of New Zealand, Aotearoa, applying to non-Māori as well as Māori as part of our common law. And I think that's really important, because we have tangata whenua Māori and we have tangata tiriti, such as myself, non-Māori. And really what we're saying is that the law, this is part of our common law, the way we create case law in New Zealand, and it applies to all of us under the treaty. And so I think it's a very important principle that when we're talking about embedding tikanga into the law, is that it's in partnership in that sense. And of course, they've been further and said that should apply to statutes. So when we're looking at new laws, legislation, exercise of discretions, policies and processes. So it's very broad reaching. And Justice Joe Williams, when he was speaking to lawyers and jurists recently, said in terms of what was required was a cognitive shift, the development of the ability to step into the shoes of someone from the partner system of law, even if imperfectly, in order to view and look at from that person's perspective. So roll on the Human Rights Commission. The Law Commission. So on the slide on the right, of course, is Te Ara Oranga, which is the Mental Health and Addiction Inquiry Report, which required essentially the Ministry of Health to review, or the government to review, the law regarding mental health and substance addiction. And so the government accepted the recommendations, which is a requirement to replace the law. So repeal the current Mental Health Act and replace it. And so there's, a good discussion about the convention in that report. Secondly, the Law Commission was referred through the Minister of Justice at the time, Andrew Little it was, that to review the law regarding adult decision-making capacity, Ngā Huarahi Whakatau, the pathway to decision-making. And so they're well underway. They've got one preliminary issues paper out. And the whole purpose of my talk is to tell you, watch the space, because the second paper will be coming out in October. And my messages, which will be at the end, hopefully I'll get there, is that it's people in the bioethics whānau community have a lot to contribute to this law, and it would be great to see as many submissions and contributions, because it is just so broad and so relevant to the work we do in the bioethics space. So capacity has made an appearance in the Mental Health Act. So there's just an amendment at this stage to abolish or remove indefinite compulsory treatment orders. These are orders that are either inpatient or in the community level, and that is the basis that we take people without consent under this wing of the Mental Health Act. And that's when they meet the definition of mental disorder, which is that they have a mental health condition, and also that they could harm themselves or others, or have diminished care to look after themselves. So the interesting thing is, so this stands out, having indefinite treatment orders. So these orders are made 6 months plus 6 months, and then they become indefinite. And there is an ability to review them in the Mental Health Review Tribunal. But believe me, someone that works in this area, it's quite hard to get someone off an indefinite treatment order. And one of the issues, of course, is institutionalisation, I'd add. but we could spend some time talking about this. What you need to know though is that capacity is turned up under section 34D of the Act. So they're saying, well, now you're going to have to, we're only going to put, and you'll come off your indefinite treatment order, but if you consent, we'll extend it 12 months. So here we have a compulsory treatment law without consent, saying to people, oh, by the way, if you'd like to stay another 12 months with your consent, which has been certified, and interestingly, by a solicitor, not a barrister, so not all lawyers, just a solicitor, then, and that's provided in writing. We won't give you a hearing or anything, but if you consent, will keep you under for another 12 months. It's a bit odd. And, given, it's great that they've moved quickly to remove the indefinite treatment orders, and my hat goes off to, the Ministry of Health pushing for that. And it was very clear that we couldn't sustain a compulsory treatment law that had those kinds of orders from a human rights perspective. But this is a bit odd. I mean, I've just come from giving a presentation to the Southland Law Conference. There's 2 mental health lawyers down there, and they're both barristers. So I don't know if they're going to, I find it very odd to think, and how are we going to decide whether that person has capacity to consent? I've got other slides which show that in my review was that, up to 1/3 of people in psychiatric institutions lack capacity to consent. Of course, that means that the human rights issue is that there's 2/3 of people that could have capacity to consent or refuse. So it's a bit odd, but it is a move towards, making the law last resort. So the Law Commission's got a lot on its agenda, and I was just going to focus on 2 areas. One is ethics, values and tikanga, and the other is just a little bit about looking at ways of putting supported decision-making into law. So there's a lot of terms, concepts, principles, legal principles, ethical principles, processes, it's sort of all around procedural justice as well. So we as ethicists are used to that idea of ethical principles being in conflict. So, broadly autonomy, as long as, if you've got capacity, you can do anything you like, as long as you don't harm other people, sort of a mill sort of on liberty sort of approach. Kind of, this is what we think is in that person's best interest. And so there's a whole discussion, of course, about what is meant by best interest and how we construct decisions that might take into a person's point of view, wills and preferences, and that's also part of the discussion around that. So, and as I say, to be fair to the PPPR Act, its mandate is to promote the autonomy, protect or promote the rights of people with incapacity, and against, protecting them from harm, because the bottom line is that courts are there to protect people. It's very paternalistic. And, once you've represented a lot of people that have been, had abuse, misuse of enduring powers of attorney, that all sorts of rings have been kidnapped by their families, real liberty, habeas corpus sort of issues, it is there to protect. So I don't think we should be ashamed or about that. So we've got John here who, in terms of our book, we talked about these sort of 3 sort of main principles that we felt that went across the work. Liberty in the sense of freedom of choice and autonomy in that sense, well-being and do no harm. Because of course there is this issue about if we're all trying to intervene and do things that we actually have to stand back and say is, are we actually harming just from being overly involved? So, so against that, we also do have a number of examples of Māori concepts embedded in law and practice. And I just want to give a couple of examples. One is mana, respect for the person's mana, and that sits actually in the Substance Addiction Act, which has a purpose of restoring the person's capacity. So the idea is, although you try and bring them under this regime if they lack capacity, your purpose is to restore it and to respect the mana and dignity. And the other one that I wanted to draw attention to, it shouldn't have a macron actually, is whakawhanangatanga, which is Joe Baxter is one of our authors in our book and helped us with establishing the toolkit. We've got a section there about using that idea of establishing relationships and connections with people, engagement as a platform for supported decision making. And that's particularly in the context where we're using it for an assessor who comes along and says, well, I'm going to interview you and assess you as to whether or not you have capacity. So, of course, the Law Commission, I should say, has got its own, is writing a report on tikanga. It's got its own Māori expert committee for this project. And, you know, there'll be a point, I think, where it will come together. And they are looking at various sort of specific terms and contexts. One would be, if you think of te whare tapawha and the idea of hine ngaro in terms of the mind. Also, they've got pōrangi and wairangi in terms of confusion and states around that. But, you know, there's a lot to be done in that space. My real point is that I'd like to see a real partnership in ethics discussion with the tikanga, because I think that would make it very innovative and good legislation. So supported decision making. So this isn't defined in the convention, but it's essentially what we're talking about here, which is that idea of requirement to put support measures in and against that, making sure there's legal safeguards. And what we're talking about is front-end support measures. So, and accommodating people with disabilities so they can maximize their ability to either make their decisions or be supported in making those decisions. So we think of support for legal capacity as a continuum, supporting a person to express their core values, wills and preferences. So, and we have roughly, at the left there, we've got informal supported decision making. So we're all used to different scenarios where our families, our friends, whatever, support the person. Then there's this middle space about having, and that's really what the new law will be about, is if we're going to have a more formal recognition of a supporter, what would that look like, and how are they recognised in law, and what are the safeguards to ensure that they're not going to misuse that authority. And then if we go to the sort of adult guardianship law revision down the right hand side, it's where we have, when we do actually go to court to appoint someone. And that's really in a representative capacity. Old terms would be a proxy decision maker. There's tendency to refer to a substitute decision maker. I don't really like that. But, you know, it is in a representative capacity. So if you're a welfare guardian, you're there because you're representing the person around certain healthcare decisions or their living arrangements. So we could come back to this, but if you've completely lost in all this legal chat from me, those are case studies just really taken out of our book, actually, in terms of the consent to healthcare, which I just thought, you know, just gives an example. It's easy when people consent to healthcare, if you give them time, support, information and appropriate accommodations. This man with disabilities, scared of needles, you know, yes, I will take that medication, that now I've gone away and thought about it and come back and, you know, you're explaining it to me and I can say I understand what you're doing. It's different, isn't it, when we get into what John calls the asymmetry problem, when there's a treatment refusal, those sort of classic English law cases. And so, you know, it does raise issues about to what extent a healthcare professional is required to support a person to be able to give consent or refuse an intervention that they consider to be life-saving. You know, are they the supporters or is it only the other people? You know, because I would argue actually like a capacity assessment, that process itself is a supported decision-making process, because you're actually trying to maximize that person's ability for the assessor to say, well, I know actually, you know, got all the relevant information in this person, and I think they can use that information to decide, you know, where they live. Or we've given them their glasses and their hearing aids, and they now can hear me. And actually, yes, you know, there's lots of, I think one useful thing in all of this will be to think about what does it mean, you know, supported decision making, and just to reflect that there are a number of laws that are happening out there. Probably the most significant one is the Assisted Decision Making Capacity Act 2015. When I went to Ireland in 2015, they were just repealing the Lunacy Regulations Act 1871. So they went from a presumption of incompetence to a presumption of competence or capacity. So they came from a long way, and they're actually now sort of leading the field. They've got a supported arrangements, agencies, and, you know, a lot of this requires, of course, the support measures requires the resourcing and how you're going to make this all happen in practice. But in terms of the law, the interesting thing about this law is that it sort of has tiers of supported decision-making. So a decision-making assistant is a person that can make assist you. You are the decision maker. Then there's a co-decision maker. Then there's someone, an attorney, which would be like making an enduring power of attorney. And then there is the representative, a court-ordered person. And that's similar to the New Brunswick law, which is loi sur la prise des décisions accompagnées et la représentation. So they've got a similar, so they're building in this sort of middle space where you have formally recognising the supporter's role as a supporter. And there's some work being done in Victoria. There's a new legislation there, but they've still got a way to go. So there's a lot of questions around this. So what kinds of levels of supported decision-making arrangement we're going to have? Should there be a threshold? Should I, the person, be able to appoint my own person or my own supporter, or should it be done by the court or the tribunal? And are we going to then have a threshold of having capacity to do that? And what sort of safeguards? Are we just going to end up being like making enduring powers of attorney? So there's a lot of devil in the detail, I think, in this. The other thing is, so where it's not possible, you know, should the court be involved? Should you have be able to have more than one formal supporter? And would it be less intrusive than the appointment of a representative? And then, and importantly, what safeguarding can you sort of build into that? So looking forward, Ture hira ki te tāhuta o te rangi. So I think building in supported decision-making and tikang in law will be the key aspect of the revised legislation. Law reform requires a whole of government approach and a cohesive interface with other laws. And you guys, all of us, can really add real value to the changes to the mental health and capacity legislation. The theme always being, as it was in my report, Nāku, I've got to spell, that shouldn't be there. Nāku te rauro, no te rauro, ka ora ai te iwi. With your basket and my basket, the people will flourish. Ngā mihi kia koutou. Thank you.
We might see through any questions online and then come back to the room. You can
I muddled that, so I can unmuddle it. I just
shall I
minimized
stop
it.
share so we can see?
Yeah.
Oh, you've got it, great, thanks.
If you stop share,
Yep.
is that okay?
Yep.
Then this can be full screen. There you go.
So, Ben has got his hand up. You're Ben.
Kia ora, Angela, Alison, lovely to see you. I've become a bit more cynical about capacity assessment in the role I have chairing the Welfare Guardianship Trust, and the number of medical assessments that I've seen, which are just sort of forms where someone's ticked off and signed at the bottom, lacks all capacity. And I absolutely get what you're saying about done in the right hands with a supportive intent. It can be a supportive thing, but I think in many settings, it's an incredibly mana diminishing process. It's about deciding whether I'm going to take away some of your decision making. One of the other flaws that strikes me is the whole problem with vaccine refusers. They don't weigh and decide about the information I give them. They don't believe it. Does that mean they lack capacity? I'm not sure. So, and then the final story was about the geriatrician on the Wairarapa who was being pressured, he felt, by some of the rest home owners to declare people who lacked capacity because they didn't like them. They were noisy or loud or whatever, and they wanted to put them into the dementia units. So I think building it along a capacity assessment thing on a premise that it's done well, I have some reservations around.
Okay, oh well, there's a lot in there, Ben.
All right.
Yeah, first of all, I'd like to mihi Ben, because actually Ben and I are both on the, I should declare, on the expert professionals committee for the Law Commission. Of course, what the Law Commission writes and what we say and do is, two different things. But yeah, so Ben and a number of others, people I'm sure you may well know. Well, Ben, there's a lot in that. I mean, the reason why we set up the toolkit for assessing capacity was to give Te Ao Marama, to use the words of the Chief District Court Judge, a spotlight on people with disabilities in terms of giving some transparency about how those decisions are made. And we only ever said that it was a first step towards a code of practice. So that's just, capacity assessment is just one aspect. There's a lot of decisions that are made before you get to the point of needing a capacity assessment. So if we are going to have this bright line in law where those without capacity do have a representative or someone that makes decisions for them, and how we decide that, point of the whole process is to give some transparency to what doctors do. And so that you're quite right, we don't, as a court-appointed lawyer, I don't, when the doctor ticks the box and with no reasons, I say, well, that's not enough for me to satisfy the court that you've overturned that presumption of capacity. So we do need to, two capacity assessors might come up with two different decisions, but it's about, in the end, it's a legal decision. It's a legal decision if healthcare people, like a doctor, makes a decision under Right 7.4. They're actually deciding that this person lacks capacity and I'm going to make a decision in their best interests. So, but what the capacity assessment, because it goes to the court, it actually does have more, transparency on it. As for all the other things that you mentioned, I mean, it's a lot of this is about education, and I'm very proud to have poho kiraru. I'm a proud puffed up kiraru that with John and Greg and I, that we've managed, and yourself Ben, that we've managed to be part of the professional education of doctors in particular, but other health professionals around us, so that and that I could speak to GPs and they have heard of the Convention on the Rights of Persons with Disabilities. I can tell you there are a lot of lawyers that haven't. So, in terms of that, what was the question about vaccines?
Do they lack capacity because they don't weigh the information?
Yeah, but that if they don't weigh it, if they don't not only don't understand, they don't accept the information. They say, well, sorry, I don't believe you, you're wrong. It's then very hard to find out whether they can weigh it or not. Right.
Yeah, we could probably spend a bit of time on that. But, there is a basic right to refuse medical treatment in New Zealand. And, you might not agree with what their position is, or you might not agree on how they understand it. Yeah, I think there's a lot in that. Any other questions?
So I can see why a supportive decision-making model is quite a radical change from the mental health capacity. That that seem on paper anyway, it would look really different. For the adults who lack capacity situation, is one way of thinking about it that a lot of people don't have an enduring power of attorney in place. So we want to kind of provide mechanisms for them to benefit from that kind of situation, even if they haven't actually set it up yet. Is that sort of like a kind of a temporary or decision by decision ability to bring someone else in to help them make the decision or to even make it for them? Those are the sort of, is that a way of thinking about those first two? And then I guess that the thing that seems so hard about that is, how do we protect people from being supported into a decision that really isn't theirs? Like, so is that, I mean, have you got thoughts about that in particular? Like,
right, well, the first question was really, it's really addressing the fact that a lot of people don't support a decision making, don't have enduring powers of attorney, and that's quite correct. It's not an accessible system at the moment. It has, what did go to the Law Commission back in 2000, 2001, and then unfortunately they didn't create a register at that time. So that would be one thing, but that's quite right. And there is an equity, there's a health equity issue here. So I represent, a lot of people that have families that are unable, to essentially support people in terms of them, when a requirement is they have to go to court to have a welfare guardian or property manager. So you're quite right. We need to make the whole area of having, whether it's be an EPOA or having support people help us, much, much more accessible. And part of that is that we've never had a public office that champions this area of the law. We don't have an office of the public advocate or the office of the public guardian like they do in the UK. And so that's, so yes, we do. And, at the moment, they simplified the forms for their 12 pages. And honestly, I've been in front of lots of doctors. They don't really understand.
hundreds and hundreds of dollars.
And they cost, so it's not an accessible system. That's a very good point. Secondly, your second question was about
safeguards for making sure that someone who gets a family member or a friend is supporting them in a decision. What's the safeguard against that person basically just coercing them into a decision?
Well,
that seems like the big kind of
so that's part of the issue about, whether you'd personally be able to appoint your supporter or whether you'd go through some more formal process to recognise that. Because the strength of having representatives in the court orders like welfare guardian, it's the oversight from the court. I mean, as a court-appointed lawyer, I've taken many welfare guardians back to court, or, families back to court because of, this welfare guardian order is not working. There's a lot. That is like a simple example. Represented a man who's a woman, an elderly woman whose son walked off George Street here in Dunedin, walked to the bank and the son said, I'm going to mum's here, we're going to withdraw $100,000. And they did, and walked out of the bank. So, how, if your son is your supporter, how are you going to protect against that kind of situation? So, I mean, yes, there's a lot to be worked on. And that's where I think codes of practice and guidelines that, would actually be very useful particularly in the health and, disability sector, about how it would all look like.
Well, but maybe also in banking.
Well, that's right. I mean, the whole thing is the shift is really to make the court process a place of last resort. And if as much as we can do without ever needing to go anywhere near the court. But we need a simple, clear law that sets out good processes around that.
My question is, how do you handle the person who perhaps has marginal capacity but has the particular problem of changing their mind back and forth multiple times? And one of the things that when I studied this capacity assessment in the US many years ago, that they made holding an opinion over at least a brief period of time as part of the capacity assessment. How do you handle that here?
Yeah, so that's difficult in law. I'm trying to put a legal focus on it. So essentially fluctuating capacity can be very challenging. You know, in practical terms, if you're doing a capacity assessment, someone with dementia, you know, it's well known it's better to go at the beginning of the day rather than at sundowning when people, you know, kind of get tired and they're not all together there. So, you know, there are practical ways. That's why I'm saying, you know, capacity assessment can be a very supportive process to put the person who has fluctuating capacity in their best position. But in terms of how you build it into law, because capacity is decision and time specific, and that's the rub here, because if your capacity fluctuates, then, you know, does that mean you've got to do, you know, capacity assessment every 5 minutes, you know? And so that substance addiction treatment law is a really good example of that. So, you know, because they've had to build in capacity assessments all the whole way in. So people might get this far in and they've almost got them under the compulsory treatment law, and then the person regains their capacity because they've come out of their substance addiction. You know, so it is very challenging, and there is some case law about the extent of over time frames, you know, and looking at it in a more holistic way. But it's a discretion, actually, really, exercise of a discretion as the person has fluctuating capacity, and it's challenging.
We should probably finish up. I'll stop the recording, but we can probably hang around for a few more questions. I might say that next week there's a seminar on humility and bioethics that I'm convening, and sometime between now and then I will write that talk next week.
You've got my slides, so yeah, the slides are available to anyone that wants them too. And yeah, just to me hear you all really. Yeah, so yeah, it's an active thing, and you know, really do want to send the message that apart from, you know, from the academic side of things, there's plenty of potential publications. But what I'm saying is all of us here